Good evening, everyone. I, Kritika Goyal, warmly welcome you all to today's special class by LiveLaw Academy. Today's session is on taking cognizance of an offence by a court of session and by a special court. Before we begin, it is both my honor and privilege to introduce the guiding force behind this session, Justice V. Ramkumar, sir, our patron and chief mentor at LiveLaw Academy. Justice Ramkumar, sir, is a distinguished former judge of the High Court of Kerala. Sir began his legal journey with an LLB from Government Law College, Mumbai, and enrolled as an advocate in 1979. In 1987, Sir was directly recruited as a district and sessions judge. Sir later served as a law secretary to the Government of Kerala and was elevated as a permanent judge of the Kerala High Court in 2004, a position which Sir held with great distinction until his retirement in 2012. Over the years, Sir has also served as the chairman of the advisory board under the Kerala Anti-Social Activities Prevention Act, as well as the ombudsman for the Kerala Cricket Association. Sir is a much sought after speaker, regularly invited by judicial academies, law universities, and the Bar Council to address judicial officers, prosecutors, and students. Sir's contribution to legal literature includes acclaimed books like Law of Prevention of Corruption, Tendering Pardon to an Accomplice, and Magisterial Trials, Law and Procedure. Sir's unique Q&A style, legal articles on live law have helped decode tough concepts for students and practitioners alike. Now, without further ado, let's all welcome Justice Ramkumar, sir.
Thank you, Kritika. Now, in the previous sessions, we had seen the process of taking cognizance of an offence by a magistrate on a private complaint, on a police report, etc. We had also seen the 4 sources for taking cognizance of an offence available to a criminal court, of which the main 2 sources which come up for trial before criminal courts are private complaint and police report. Today we are going to familiarize ourselves with the process of taking cognizance of an offence by a court of session and by a special court. We'll first read the first question on that issue. Please, Kritika, please read question number 1.
So, question number 1.
Yes.
A private complaint is filed before a court of session alleging the commission of certain offences under the Bharatiya Nyaya Sanhita 2023, that is BNS for short, corresponding to the Indian Penal Code 1860, IPC for short, some of which are exclusively triable by a court of session. Relying on the Constitution Bench decision in A.R. Antulay versus R.S. Nayak, 1994 to SEC 500, wherein it was held that a special court, which is a deemed court of session, can take cognizance of an offence on a private complaint. It is alleged that the sessions judge is competent to entertain the private complaint. The sessions judge takes cognizance of the offences and records the sworn statements of the complainant and the witnesses present and issues process against the accused. On receiving summons, the accused challenged the proceedings of the sessions court before the High Court. Will they succeed?
I suppose you have understood the question. A private complaint alleging offences, some of which are exclusively triable by a court of session, is filed before a court of session directly. The petitioner's counsel, the complainant's counsel, or the complainant himself, let us assume that he is a lawyer. He relies on the Constitution Bench decision of A.R. Antulay versus R.S. Nayak, 5 judges judgment, wherein they held that the special court under the Prevention of Corruption Act 1988, who is the deemed court of session, can take cognizance of an offence on a private complaint. Relying on that, the complainant tells the session judge that Your Honor can take cognizance of the offences on this private complaint. Kindly take cognizance and issue notice to the accused. Session judge, relying on this A.R. Andule versus R.S. Nayak, takes cognizance, issues summons to the accused. On receipt of summons, the accused moves the High Court and challenges the order taking cognizance on the ground that it is bad in law. The question is whether the accused will succeed or not before the High Court.
If anyone wants to try and attempt the question, they can put it in the chat box, the answers.
All right, I'll give you the answer.
Yes.
You can check up yourself whether you are right or wrong.
Yes.
The accused persons who have moved the High Court, they will succeed because the sessions judge was not right in proceeding to take cognizance of the offence in flagrant violation of section 213 of BNSS corresponding to section 193 of CRPC, which says that except as otherwise provided by the BNSS CRPC or by any other law for the time being enforced, no court of session shall take cognizance of any offence as a court of original jurisdiction unless the case has been committed to it by a magistrate. Now, the reliance placed on the verdict in A.R. Andule was misconceived because the Constitutional Bench was dealing with the special judge under the Prevention of Corruption Act 1947, read along with the Criminal Law Amendment Act 1952, that is Act 46 of 1952, as per which the special judge who is deemed to be a court of session could take cognizance of the offence directly without a committal. That was the special feature of the special judge, though deemed to be a court of session. But here it is a court of session pure and simple, and a private complaint is directly filed before the court of session. Court of session should have said an emphatic no. You have to come through the magistrate. You file it before the magistrate and let the matter be committed to this court. I can take cognizance of the offences as a court of original jurisdiction only if the case has been committed to me under section 193 CRPC corresponding to section 213 BNSS. So the accused will definitely succeed, and the High Court will set aside the order taking cognizance and will direct the complainant to prefer the complaint before the committal magistrate. And it has to come through the committal route. I suppose you have understood the question. A.R. Andule was unnecessarily given by me only to confuse you. A.R. Andule, the special court, had the power to directly take cognizance without a committal. But here it is a court of session, pure and simple. Yes. We pass on to question number 2.
Yes, sir. So question number 2. In the year 2004, a case instituted on a police report involving an offence punishable under section 325B of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, the SCST Act for short, was directly taken cognizance of by the special judge without a committal of the case. The special court tried the offence without any demur by the accused. Challenging this conviction and sentence passed by the special court, the accused filed an appeal before the High Court, contending inter alia that the trial conducted by the special court without a committal under section 193 CRPC was without jurisdiction and unsustainable. The accused also relied on 2 decisions of the Supreme Court of India in Molly versus State of Kerala, AIR 2004 SC 1890, which is 2004 4 SCC 584, Vidyadharan versus State of Kerala, AIR 2004 SC 536, that is 2004 1 SCC 215, which held that trial under the SCST Act without committal is vitiated. Will the accused succeed?
I suppose you got the question properly. This is a case which arose in 2004. Now there is some distinction between the see, on 26/1/2016, the SC/ST Atrocities Act was amended. This is a case before the amendment. Before the amendment, the special court under the SC/ST Act was a court of session, pure and simple. Now, disputes arose before various high courts whether the special judge could take cognizance without a committal. Now, in fact, in Kerala, a full bench of the Kerala High Court had taken the view that being a special court, it can take cognizance without an acquittal and without a committal. It can directly take cognizance without a committal. That is the view taken by the Kerala High Court, a full bench of the Kerala High Court. There were other high courts also taking similar view. Some high courts took the view that no, it has to be committed to the special court by the magistrate concerned. This controversy was set at naught by a beautiful decision by the Supreme Court, speaking through Justice K.T. Thomas in Gangula Ashok versus State of Andhra Pradesh. Gangula Ashok versus State of Andhra Pradesh. AIR 2000 Supreme Court 740. AIR 2000 Supreme Court 740, corresponding to 2002 SCC 504. Justice K.T. Thomas beautifully explained the provision. In fact, Section 14 of the SC/ST Act what it says is the state government may specify a court of session to be a special court for trial of offences under this Act. Accordingly, special courts were specified. So, what is it that is specified? A special court, the state government is given the power to specify a court of session. Supposing there are several courts of session in a particular district. State government was given the power to specify one or two of them to be special court under the SC/ST Atrocities Act. Therefore, if what is specified is a court of session, it is a court of session only, though called as a special court, without any further modification by the special act. Special act does not say that the court of session, this special court, can directly take cognizance of offence without a committee. Does not say. In 2004, it didn't say that. Until 26/1/2016, the special act, the SC/ST Atrocities Act, did not say that the special court can take cognizance directly without a committal. Therefore, this is a case where the special judge who took cognizance of the offence without a committal, it was wrong. In fact, the two decisions referred to, that is Moli versus State of Kerala and Vidyadharan versus State of Kerala, are two decisions of the Supreme Court which held that a trial by the special judge without a committal is illegal and the trial is vitiated. This is what the two judges bench of the Supreme Court held in those two decisions which arose from Kerala, State of Kerala. But then that decision was overruled by a three judges bench in Ratty Ram versus State of Madhya Pradesh, AIR 2012 Supreme Court 1485, AIR 2012 Supreme Court 1485, corresponding to 2012 4 SCC 516, three judges. The judges are Dalvir Bhandari, T.S. Thakur and Deepak Misra, Justice Deepak Misra being the author of the judgment. They held that though trial without a committal, if not object, is wrong, but then if the accused does not object to the trial without a committal, it is only a curable illegality and the trial will not be vitiated if the accused participated in the trial without any objection. So, participation in the trial by the accused without any objection regarding the want of committal will not vitiate the trial. The court, the three judges bench, overruled those two decisions and held that if the accused had participated without any objection in the trial, then just because there was no committal of the case to the special court, you can't say that it is an incurable illegality. No, it is only a curable illegality. Therefore, if the accused, it is possible for the accused to waive his objection. And if he participates in the trial, waiving his objection or without raising any objection, then the trial is valid. This is what the three judges bench held. Of course, now after 26/1/2016, with effect from 26/1/2016, the Act has been amended. Section 14 has been amended, and the special judge is now given the power to take cognizance of the offence without a committal. You got the point? You got the question? So this is a case where the case ought to have been committed to the Court of Session because this was prior to the amendment. But then it was not committed. But the accused did not raise his objection during trial. Therefore, the trial is valid, as held by Retiram versus State of Madhya Pradesh, which had overruled the two decisions relied on by the accused. Yes. We pass on to question number 3.
Yes, sir. Question number 3. It is well settled by judge-made law that a case and a counter case or a cross cases are to be tried by the same judge. In one instance of a case and a counter case, the main case is pending trial before the additional sessions judge. After entering appearance before the additional sessions judge, the accused persons file a petition before the sessions judge seeking a transfer to the additional sessions judge of another case pending trial before the judicial magistrate of the first class, stating that the case before the magistrate is a counter case to the main case pending before the additional sessions judge. The cases involved in the counter case pending before the magistrate are not triable exclusively by a court of session. The sessions judge, on being satisfied that the two cases are case and counter case, that is cross cases, transfers the counter case pending before the magistrate to the additional sessions judge in exercise of his power under section 448 BNSS, that is section 408 CRPC, read with section 447(1)(4) BNSS, that is section 407(1)(4) CRPC. Is there any illegality in the order passed by the sessions judge?
I suppose you got the point, the question. The questions are slightly confusing, but then there is a judge-made law. You won't find any provision in the BNSS or CRPC to the effect that case and counter should be tried by the same judge. No provision. What is a case and counter? What is a case and counter? Case and counter are rival versions of the same occurrence. Occurrence is the same. A party, there are few accused persons in A party, few accused persons in B party. Now B party attack the members of A party and one of them is murdered. The A party also made a counter attack and a few are injured in that occurrence. Now there is a occurrence is only same. Rival versions of the same occurrence. So A party will say that B party were the aggressors. They were the aggressors and they killed one of us. B party will say that no, A party were the aggressors and they caused injuries to some of us, though we had to counterattack and kill one of them. So the question is, which version is the true version? There are two versions with regarding to the same occurrence, two rival versions with regard to the same occurrence. So the court will have to decide as to which of the two versions is the correct version. In which case, both case and counter case will have to be tried by the same judge. But unfortunately, there is no provision in the CRPC, in the BNSS also. Therefore, judges by their experience, through their experience, took the view that both cases should be tried by the same judge. Otherwise, the main case may end up in an acquittal, counter case may end up in a conviction, or vice versa. With the result that each of the judges will not know the position regarding the opposite party. Therefore, courts have evolved. You can call it a judicial activism. Courts have evolved a principle that if the cases are case and counter, case and counter case, cross cases, then both cases have to be tried by the same judge so that he will get a complete perspective of the entire occurrence. That is how this principle was evolved. Now here is a case and counter. Now problem is the main case is a murder case. One of them was killed. So main case is a murder case, so it has to be tried by the court of session. Now that has been committed to a court of session and session judge has made it over to the additional session judge. Main case is pending before the additional session judge for trial. Now the counter case, there the offences are not exclusively triable by a court of session. Therefore, the counter case came to be filed before the magistrate. Magistrate will have to try the case. In which case, the case and the counter case will have to be tried by two different judicial functionaries, one by the additional session judge and the other by the magistrate. Therefore, what happened was the who moved the session judge, I think the accused, no, the offence was magistrate. The session judge, on being satisfied that the two cases are case and counter, transfers, because he transferred the counter case from the court to the magistrate to the session court and to the additional session court. Because the judgment law is there. Both cases have to be tried by the same court. Main case is pending trial before the additional session judge. This counter case is pending trial before the magistrate. So in order to bring both cases before the same judge, the session judge, by exercise of his power under section 448 read with section 447 BNSS, transferred the case pending before the magistrate to the additional session court where the main case is pending. That is how he brought both cases together before the same judge to comply with the judgment law that both cases have to be tried by the same judge. Now the question is there any illegality in the order passed by the session judge? We have already seen that a court of session under section 193 corresponding to section, see that section 213 of BNSS, section 193 of CRPC corresponding to section 213 of BNSS says that a court of session shall not take cognizance of an offence as a court of original jurisdiction unless the case has been committed to him. Now, with regard to the main case, it was committed to the court of session and session judge made it over to the additional session judge for trial. Regarding the counter case pending before the magistrate, what the session judge did was to transfer that case to the session court. Now, this is a case where session court is called upon to take cognizance of the offences on a transfer, not on a committal. That transfer order was bad. It had to be committed. Now, this is not an ordinary case where the offences are exclusively triable by court of session. Offences are not exclusively triable by a court of session. Therefore, ordinarily, it would not have been committed to the court of session under section 209 of CRPC corresponding to 232 of BNSS. Therefore, how to get the case committed to the court of session? There is a provision under section 232 CRPC. That is, 323 CRPC. 323 CRPC. I don't remember the corresponding section. 323 of CRPC says that if a magistrate, if during the trial before him, magistrate is of the opinion that the case ought to be tried by a court of session, not necessary that all the offences should be exclusively triable by a court of session. If the magistrate is of opinion that the case ought to be tried by a court of session, the magistrate can exercise his power under section 323. I will give you the corresponding section. 323, 362 of BNSS. by virtue of 362 BNSS, the magistrate can commit the case to the Court of Session by in exercise of section 362, that is corresponding to section 323 of CRPC, to the Court of Session on the ground that according to him this case ought to be tried by the Session Court. Now, being a counter case, it has to be tried by the same judge. Now, one judge is already in season of the main case, that is additional session judge. Therefore, in order to enable the additional session judge to try the counter case, magistrate can commit the case under section 362 BNSS to the session court, and the session judge can make it over to the additional session judge for trial. Now, the mode of bringing the counter case to the additional session court was wrong here. The session judge could not have transferred the case. He should have got the case committed to the Court of Session, or he should have requested the magistrate to commit the case to the Court of Session in exercise of his power under section 362 BNSS corresponding to 323 CRPC. That is the mistake committed by. Now, on the question whether the case and counter case should be tried by the same court, I will give you two citations. One is Sudhir versus State of Madhya Pradesh. Sudhir versus State of Madhya Pradesh. AIR 2001 Supreme Court 826. Justice K.T. Thomas and R.P. Sethi. Justice K.T. Thomas being the author. The observation is this. We think that the fair procedure to adopt in a matter like the present, where there are cross cases, is to direct that the same learned judge must try both cross cases one after the other. Now, how to implement that scheme? That also was considered by Justice Thomas. How to implement the said scheme in a situation where one of the two cases relating to the same incident, charge sheeted or complained of, involves offences or offence exclusively triable by Court of Session, but none of the offences involved in the other case is exclusively triable by Court of Session, as in our case. The magistrate before whom the former case reaches has no escape from committing the case to the Session Court as provided under section 209 of the Code, because it is a case exclusively triable by a Court of Session. Once the said case is committed to the Session Court, and thereafter it is governed by the provisions contained in Chapter 18 of the Code of Criminal Procedure. Though the next case cannot be committed in accordance with section 209 as the ordinary case of the court, the magistrate has nevertheless the power to commit the case to the Court of Session, although none of the offences involved therein is exclusively triable by the Session Court. Section 323 is incorporated in the code to meet such contingencies as well. 323 is corresponding to section 362 of BNSS. So, there cannot be a committal of the counter case under section 209, because 209 contemplates a situation where offences are exclusively triable exclusively by a Court of Session. Here the offences are not triable exclusively by a Court of Session. But the magistrate has got the power under section 323 CRPC corresponding to section 362 BNSS, wherein it is enough that the magistrate feels that the case ought to be tried by a Court of Session. This is one such case. Because of the judge-made law, that case and counter case should be tried by the same court. Now, regarding the same judge, regarding the principle that same judge should try both the cases, you may refer to Nathilal versus State of UP, 1990, Supplementary SCC 145. 1990, Supplementary SCC 145. Judges are MP Thakkar and BC Ray. MP Thakkar and BC Ray. They have held that same judge should, in fact, in the other case also rendered by Justice Thomas, there also it is observed that same judge should try both the cases. Now, I will give you a parallel situation. You know, the Essential Commodities Act 1955, to be abbreviated, the EC Act for short, was enacted for the purpose of preventing the hoarding and black marketing of essential commodities like rice, sugar, kerosene, etc., to enable their equitable distribution among the consumers. Offences under the EC Act are triable by judicial magistrates only. As per Section 12 Cap AA, Section 12 AA of the Essential Commodities Special Provisions Act 1981, offences under the EC Act were, for a period of 15 years only, made triable exclusively by a special court to be presided over by a special judge who was qualified to be appointed as a judge of the High Court, or who had been working as a session judge or additional session judge for a period of 1 year or more. For 15 days, this particular enactment provided trial under the EC Act, not by the magistrate, but by a special court, who was to be, which was to be presided over by a session judge or additional session judge, at least for 1 year. Therefore, consequent on the constitution of the special court, the High Court of Rajasthan, in a few cases then pending before the competent judicial magistrate for the CBI, transferred those cases to the special court for trial. Mind you, transferred. High Court transferred. The above transfer was challenged by the accused before the Supreme Court. The apex court held that special court, which was presided over by an additional session judge, could take cognizance of the offence only on a committal under Section 193 CRPC, and accordingly, the order of transfer was set aside, and the cases were ordered to be sent back to the magistrate for disposal according to law. They were pending before the magistrate. In the meanwhile, this special enactment came into force, enabling trial by a special court for 15 years. Actually, that is a supervening subsequent enactment. But the case was already pending before the magistrate and was pending trial before a magistrate for cases triable by magistrate for CBI, CBI cases. So the Supreme Court directed set aside the transfer and directed the case to be sent back to the magistrate for trial according to law. The citation is Jagdish Prasad Gupta versus State of Rajasthan, 1995, Supplementary 3 SEC 386, 1995, Supplementary 3 SEC 386, corresponding to 1995 SCC Criminal 924. The judges are Jayachandra Reddy and Dr. A.S. Anand. Justice Jayachandra Reddy and Dr. A.S. Anand. I suppose you got the point. If it is a court of session which does not have any special privileges, then it can take cognizance as a court of original jurisdiction only if the case is committed to it by the magistrate concerned, not otherwise. A transfer of the case to the court of session will not do. Likewise, a private complaint cannot be directly filed before the court of session. It has to come before the magistrate initially and then to be committed to the court of session. Position is the same with regard to police report also. Even if in a case exclusively triable by a court of session, the police will have to file the police report, charge sheet, before the magistrate only. It is the magistrate who will ultimately commit the case to the court of session for trial. Yes. Now we pass on to question number 4.
So, question number 4. If the offence is one triable exclusively by a court of session, can there be a cognizance of the offence both by the committal magistrate as well as by the court of session?
I told you that whether it is a police report or a private complaint, it has to be initially filed before the magistrate. Then the magistrate will eventually commit the case to the court of session. court of session can take cognizance only on a committal. Now, therefore, two courts are involved. Now, the question is whether both the courts can take cognizance of the offence. A full bench, a constitution bench, in paragraph 28 of a constitution bench decision of the Supreme Court in Dharampal versus State of Haryana, Dharampal versus State of Haryana, AIR 2013 Supreme Court 3018, AIR 2013 Supreme Court 3018 corresponding to 2014 3 SEC 306, 2014 Volume 3 SEC 306, 5 judges. Altamas Kabir, Chief Justice, is the author of the verdict. There is an observation in paragraph 28 that it is well settled that cognizance of an offence can be taken only once, even though two courts are involved. Now, with due respect, I beg to disagree with the above view, above observation. When a magistrate receives a charge sheet or a complaint alleging the commission of offences of which at least one is triable exclusively by a court of session, the magistrate is taking cognizance of the offences when he takes on record, when he takes on the file, the case as a committal case. So, see, if it is if the offences are exclusively triable by a court of session, the magistrate has to commit the case. But there is a committal proceeding for which also the magistrate has to take cognizance of the offence. Supposing the offence alleged is 307 IPC, that is attempt to murder. Attempt to murder is exclusively triable by a court of session. But if the magistrate, on perusal of the records, along with the charge sheet, the police will file their record, the 161 statements, documents, etc. On a perusal of the document, the magistrate is satisfied that 307 is not involved. 307 attempt to murder is not involved, but 307 is on section 109 of Bharatiya Nyaya Sanhita, BNS. The magistrate is of the view that 109 is not attracted in the case. On the contrary, what is attracted is only section 326, causing grievous hurt with a dangerous weapon or means. 326 alone is involved. That is triable by the magistrate himself. He need not commit the case to the court of session. So that is the case where the magistrate is taking cognizance of the offence initially. Likewise, when the magistrate is satisfied that the offences are one or two of the offences involved are triable exclusively by a court of session, he is taking cognizance of those offences and registering the case as a committal proceeding. Otherwise, he will have to register it as a calendar case and try himself. He will have to try the case himself. But he is, in both cases, he is taking cognizance of the offence. Then under section 193, corresponding to section 213 of BNSS, section 193 CRPC, corresponding to section 213 of BNSS, we have already seen that a sessions court is taking cognizance as a court of original jurisdiction on committal. Therefore, sessions court is also taking cognizance of the offence on committal. Now, I will show that there is intrinsic answer in the BNSS CRPC itself to show that in a case triable exclusively by a court of session, the committal magistrate will first take cognizance of offence before committal, and after committing the case to the court of session, the session court will take cognizance of offence. There is intrinsic material evidence in the CRPC and BNSS itself. When an accomplice, the accomplice is a person who assisted who is a co-accused, who is a participant in the crime. Accomplice is a participant in the crime. See, very often there are cases where accomplices are tendered pardon by the courts. Because why tender pardon to an accomplice? It may be difficult for the court to enter a conviction or acquittal because there is no eyewitness. There may not be any eyewitnesses to the occurrence. The circumstantial evidence also may be missing. There will be missing links in the circumstantial evidence. So unless one of the conspirators or one of the participants of the crime is made a prosecution witness, it will be difficult for the prosecution to get a conviction. It is a case, according to the prosecution, it is a case which merits or which deserves conviction. But no eyewitness, no evidence available, then one of the participants of the crime will be made an accomplice, approver, and he will be examined as a prosecution witness. So, for the purpose of making such an accused a prosecution witness, an accomplice, to tender pardon to an accomplice, there is a procedure prescribed under section 306 of CRPC corresponding to section 343 of BNSS. Now, supposing the offence is triable exclusively by a court of session, then section 343(4)(a), section 343(4)(a) BNSS corresponding to section 306(4)(a) CRPC obligates the magistrate taking cognizance of the offence to examine the accomplice as a witness. Offence is triable exclusively by the court of session. Case is pending investigation before the magistrate. Now the police report and the private complaint, if any, these are all to be filed before the magistrate only. Magistrate will eventually commit the case to the court of session for trial. Now, in such a case, if one of the accused is tendered pardon and one of the accomplices is tendered pardon to be made an approver, the section says the person to whom pardon has been tendered shall be examined as a witness before the magistrate taking cognizance of the offence. So, magistrate is taking cognizance of the offence in a case triable by a court of session. Then thereafter the case is to be committed to the court of session. Then after committal, you all of you know, section 193 corresponding to section 213 of BNSS says that the court of session shall take cognizance as a court of original jurisdiction upon a committal. So there is actually two cognizance is involved. And unfortunately, I find myself to agree with the above observation by the Constitutional Bench. Of course, one day the Supreme Court may clarify the position. Yes, I suppose you are clear regarding the question. Of course, you and I are bound by the Constitutional Bench ruling. We are bound by the Constitutional Bench. But I am giving this question only to say that it may not be strictly correct to say that there is only one cognizance. Actually, there is a cognizance taking place at the magisterial level as well as at the sessions level. Yes, question number 5.
Question number 5, sir. Which is the situation covered by the words except as otherwise expressly provided by this Sanhita occurring under section 213 BNSS, that is section 193 CRPC?
Yes, I will read section 213. See, section 213 says, cognizance of offences by court of session, except as otherwise provided by this Sanhita. In 193, you will find except as otherwise provided in this code. No court of session shall take cognizance of an offence as a court of original jurisdiction unless the case has been committed to it by a magistrate. So that section itself suggests that there can be an exception. The normal rule is that court of session can take cognizance only on a committal by the magistrate. But section itself says, except as otherwise expressly provided by this code or Sanhita. That means there can be an exception under the code itself, under the Sanhita itself. Now we are considering that aspect of the section. Where the offence of defamation, punishable under section 356 of Bharatiya Nyaya Sanhita 2023, that is BSA, corresponding to section 499 of the Indian Penal Code 1860 IPC, is committed against certain constitutional dignitaries like the President of India, the governor, a minister, or against a public servant, all employed in connection with the affairs of the union or of a state in respect of his conduct in the discharge of his public functions. Section 222(2) of BNSS corresponding to section 199(2) CRPC provide that a court of session may take cognizance of such offence without the case being committed to it upon a complaint in writing made by the public prosecutor. Therefore, if the offence of defamation is committed against a constitutional dignitary like a minister, governor, president of India, or against a public servant, all employed in connection with the affairs of the union or of a state in respect of his conduct in the discharge of his public functions, then section 199(2) CRPC corresponding to section 222(2) of BNSS says that a court of session may take cognizance of such an offence of defamation committed against such a constitutional dignitary or a public servant without the case being committed to it upon a complaint in writing made by the public prosecutor. So when the offence of defamation has been committed against a constitutional functionary or against a public servant who is who with regard to any aspect employed in connection with the affairs of the union or of the state, then the public prosecutor before the sessions judge is given the authority to file a private complaint before the court of session, and the court of session is given the authority to take cognizance of the offence of defamation without the accused being committed to the sessions judge. Therefore, this is one case in the BNSS itself, CRPC itself, which enables the court of session to take cognizance of an offence without a committal. That is why, except in the wording, except as otherwise expressly provided by this Sanhita or code, or by any other law for the time being. So, except as provided by this code, this is one of that exception. This is one of those exceptions where the court of session can take cognizance of an offence without a committal by the magistrate. Can take cognizance directly upon a complaint filed by the public prosecutor. I suppose that is clear. Now, the procedure to be followed in such cases of defamation is contained in section 260 BNSS, corresponding to section 237 of CRPC. That is the procedure for trial. Now we come to the next question.
So, question number 6. Which are the situations covered by the words except as otherwise expressly provided by any other law for the time being in force, occurring in section 213 BNSS, that is section 193 CRPC?
We have seen the wording. I have read the wording initially in the previous question, except as otherwise expressly provided by this Sanhita. Expressly provided by this Sanhita. 199 of CRPC. That is in the case of a defamation, the sessions judge can take cognizance without a committal if on a complaint filed by the public prosecutor. That is an exception provided by the Sanhita itself, CRPC itself. Then it's not over. Except as provided by this Sanhita or by any other law for the time being in force. So if there is any other law, except as provided by any other law, no court of session shall take cognizance as a court of original jurisdiction unless the case has been committed to it. So if any other law provides for trial of an offence under that law by a court of session, there also the sessions court should take cognizance only on a committal. That is the wording of section 213 BNSS corresponding to section 193 CRPC. Now, which is that any other law? Can you mention any other law? We are on this question. The following are some of the laws other than BNS, IPC, where cognizance of an offence can be taken directly by the Sessions Court without a committal, even though the special judges are deemed to be session judges. The special law may deem the special judge. In fact, all those special statutes call the judges as special judges, special judge or special court. Those special judges are invariably deemed to be court of session. So basically they are court of session. So the other principle will apply. Gangula Ashok's case. If it is basically a court of session, it can take cognizance only on a committal. But then, except as otherwise provided by the special law, except as otherwise provided by the special law. Supposing the special law says that this offence under this act shall be taken cognizance of by the special court directly without a committal, then section 193 CRPC corresponding to section 213 BNSS will have no application. It will have no operation because there is a separate provision made by the special law. Now, which are those special laws? They are not covered by BNSS or CRPC. They are other laws. First of such laws are, I will give you the section 5.1 of Prevention of Corruption Act 1988. Section 5.1 of Prevention of Corruption Act 1988 says that the special judge constituted under that act shall take cognizance of the offences under the law, under that act, directly without the accused being committed to it. Without a committal, the special court can take cognizance of the offence under the Prevention of Corruption Act. So this is a provision made otherwise, except as otherwise provided. This is a provision made otherwise. Therefore, 193 CRPC, that is 213 BNSS, has no application. So the special court can take cognizance of the offence without a committal. Second situation, section 36 capital A 1D, section 36 capital A 1D of Narcotic Drugs and Psychotropic Substances Act 1985 is yet another special law wherein the special court under the NDPS Act can take cognizance of the offences specified therein without a committal. So 193 will have no application. 193 CRPC corresponding to section 213 BNSS will have no application. Then, third situation, section 5.1 of the Prevention of Corruption that we have already mentioned. Then, third situation is second proviso to section 14.1 of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, provided it is with effect from 26/1/2016. I told you that section 14 of the SC/ST Atrocities Act was amended in 2016 with effect from 26/1/2016, whereby the special judge under that act was given the power to take cognizance of the offences without a committal. Until 26/1/2016, that court was just an ordinary sessions court and it could not take cognizance without a committal. But from 26/1/2016, the special judge under the SC/ST Atrocities Act can take cognizance only directly without a committal. Then the fourth situation is section 33, section 33.1 of the Protection of Children from Sexual Offences Act. Protection of Children from Sexual Offences Act, POCSO Act 2012. Here, section 33.1 of the POCSO Act says that the special judge under the POCSO Act may take cognizance of the offences under the Act without the case being committed to it. So, without a committal, the special judge, although a deemed sessions court, can take cognizance of the offence. Then, lastly, section 44.1b, section 44.1b of the Prevention of Money Laundering Act, Prevention of Money Laundering Act 2002, corresponding to already called, shortly called, conveniently called as PMLA. The PMLA Act, section 44.1b of the PMLA Act also says that the offence of money laundering under this act can be taken cognizance of by the special court, which is a deemed court of session, without a committal. These are the other laws made mention of in section 193 CRPC corresponding to section 213. So section 213 BNSS says except as provided, except as otherwise provided in this Sanhita or any other law for the time being in force. These are the any other laws. Am I clear?
Certainly, sir.
Question number 7.
Question number 7. How does a special court take cognizance of an offence?
We have seen how the court of session takes cognizance of an offence. Ordinarily, only on a committal. Now, how does a special court take cognizance of an? So it all depends upon the legal status of the special court and the nature of powers conferred on the special court. There are statutes like the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989 prior to 26/1/2016, where as per section 14 as it stood then, an existing sessions court was being notified as a special court, I told you, without any provision regarding cognizance or procedure for trial. Therefore, Justice Thomas, speaking for the bench in Gangula Ashok's case, held that it is nothing but a court of session, simpliciter, pure and simple. Therefore, just because you call it a special court, it is only a court of session, because the section says the state government may specify any court of session to be a special court. So it is basically a court of session. And if there is no other provision in this special act, then cognizance has to be taken as a special court of session only upon a committal. And procedure for trial is sessions procedure. I told you, I gave you the citation, Gangula Ashok versus State of Andhra Pradesh, AR 2000, Supreme Court 740. Justice K.T. Thomas and Justice M.B. Shah. Justice K.T. Thomas being the author. But even here, after 26/1/2016, the special court has been empowered to take cognizance of an offence without a committal. It can directly take cognizance of the offence. Now, there are special courts under various statutes, although deemed to be courts of session, are empowered to directly take cognizance of the offence without a committal. For example, Prevention of Corruption Act 1988, PC Act, Section 5(1) empowers the special court to take cognizance of the offence without a committal. As per Section 3(1), both the central and state governments can appoint special judges under the PC Act. As per Section 3(2), a person shall not be qualified to be appointed as a special judge unless he is or has been a session judge, additional session judge, or an assistant session judge. Even an assistant session judge can be appointed as a special judge under the PC Act. Unfortunately, assistant session judges have been abolished by BNSS. I don't know for what reason. Bulk of the work in the session courts were shouldered by assistant session judges. That post has been abolished by BNSS. I don't know why. No, an assistant session judge also could be appointed as a special judge under the PC Act. Then, even though the special judge is deemed to be a court of session, as per Section 4(3) of the PC Act, the procedure for trial as prescribed by Section 4(1) is warrant procedure. See, an anomalous situation. Session judge, basically a session court, session judge, functioning as a special judge. Trial of offences is warrant procedure, not session procedure. Warrant trial procedure. Then, even though special judge is given the power to tender pardon to an accomplice under Section 5(2) of the PC Act, the said power can be exercised only after the special judge takes cognizance of the offence. But before taking cognizance of the offence by the special judge, that is, during investigation of the case, it is the magistrate concerned who alone can tender pardon to an accomplice under Section 343(4) accomplice. And after tendering pardon, the magistrate who takes cognizance of the offence has to examine the approver as a witness under section 343(4)(a) of BNSS corresponding to section 306(4)(a) of CRPC. And the case has to be committed thereafter by the magistrate to the special court under section 343(5)(a)(2), 343(5)(a)(2) of BNSS corresponding to section 306(5)(a)(2) of CRPC. Now, one welcome significant change, one welcome change brought about by BNSS is that in the case of all special judges now appointed under any law for the time being in force, if during the stage of investigation pardon has to be tendered to an accomplice, it has to be done by the magistrate concerned, and after examination of the approver under section 343(4)(a) BNSS, the case has to be committed to the special judge concerned. Please note that under section 306(5)(a)(2) CRPC, it was only in the case of a special judge under the PC Act 1988 alone that such committal was provided. In the case of other special judges who are deemed to be courts of session by the statutes concerned, the procedure for tendering pardon as is applicable to a court of session was being followed. But now the matter is made beyond any controversy that all special judges will have to, during the stage of investigation, the case, if the case is triable by any special judge under any law, if during investigation pardon is tendered to an accomplice, the case has to be, the procedure has to be done by the magistrate, and the case has to be committed to the special judge as per this above section. Then yet another illustration. As per section 36(a)(1)(d) of NDPS Act, the special judge who is deemed to be a session judge can directly take cognizance of the offence without a committal. So this is yet another situation where a special judge takes cognizance. Third, as per section 14 of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, with effect from 26/1/2016, the special judge under that act, who is also deemed to be a session judge, can directly take cognizance of offence without a committal. All enabling provisions in the special law. That is how special courts take cognizance. The case need not be committed to the special court. Then again, as per section 33(1) of the Protection of Children from Sexual Offences Act, POCSO Act, the special judge, although deemed to be, we have got a thunder showers here. That may be the reason for the breaking of the. A special judge, although deemed to be a session judge, is entitled to directly take cognizance of the offence without a committal. Then lastly, as per section 44(1)(b) of the PMLA. Am I audible? Can you hear me?
Yes, sir. Yes, sir. You're audible, sir.
As per section 44(1)(b) of PMLA, the special judge who is deemed to be a session judge is empowered to take cognizance of the offence without a committal. So, a special statute may confer power on the special judge to take cognizance without a committal, even though such special judge is deemed to be a court of session. So, unlike in the case of a court of session, the special judge can take cognizance without a committal. This is how special judges take cognizance of an offence under the special law. Am I clear?
Yes, sir. Absolutely, sir.
Yes. We have come to the close of today's session. Which are the doubts or questions?
Yes, sir. So we have a doubt. So I'm audible? So I hope I'm audible.
Yes.
Yes, sir.
Right now we are having thunder showers. So there's
Oh,
lightning, etc. There is a possibility of power getting snapped.
Right. So there's a question, difference between fast track courts and special courts, sir.
Fast track courts and special courts, they are all additional session courts only. Fast track courts are established only for fast tracking, for early disposal, PD disposal of the cases. Otherwise, no difference. Fast track courts are set up under special statutes for speedy disposal. That's all. If the offence is triable by a court of session or special court, fast track court also will be an additional session court or additional special court. That's all.
Right, sir. So another question is, sir, do we need a separate legislation to set up fast track courts, or is it set up in the same courts?
You don't need a separate legislation. There can be separate legislation as well for fast track. If all courts are set up as fast track courts, then what is the meaning? What is the difference? If all courts have to be fast track courts, then why should there be ordinary courts?
Right, sir.
Every judge is to decide cases expeditiously without any time lag. The judge cannot sit idle in the court. He has to do real work in the courts. So that way, every judge is a fast track judge, though not specifically called as such.
Certainly, sir. So according to Section 2D of CRPC, complaints can only be filed to a magistrate. Is there a contradiction?
I don't know. I didn't get the question. Contradiction in respect of what? Complaints can be filed before a magistrate, and what is filed before a police officer is not complaint. It is information. Information regarding the commission of a cognizable offence is what is filed before a police officer under section 154 CRPC, corresponding to section 173 of BNSS. But what is filed before a magistrate is not information before the police.
Right, sir. Someone has also written another doubt after
your question was incomplete.
Yes,
what
sir.
you read was
can you repeat the question? Can you put your question again in the chat box?
According to section 2D of CRPC, complaints can only be filed to magistrate. Is there contradiction when court of session takes cognizance as a court of ordinary jurisdiction in defamation cases? See, there is a specific provision. This because of the specific provision made in the CRPC or a BNSS that in the case of a defamation, of a constitutional functionary or a public servant who is discharging his functions for the betterment of the state, and when he is defamed by an ordinary person, then a special procedure is prescribed. Instead of causing any delay, the sessions judge is given the power to take cognizance directly upon a private complaint filed by the public prosecutor. After all, the damage done through defamation to a public servant should be avenged.
Right, sir. So complaint by definition is filed. So before that, so can further investigation be ordered after taking cognizance, and can reinvestigation be ordered by magistrate? Santosh sir has already answered this question in sir's previous sessions. I will share the YouTube link and the notes to the session. Okay. I suggest you can go and see those sessions.
Yes.
And the answer to this, sir, if I may just try, it's yes. Further investigation can be ordered after taking cognizance.
In fact, further investigation can be filed only after the police file a charge sheet. So only after the filing of a charge sheet that further investigation can be ordered, and that can be done before or after taking cognizance of the offence. There are decisions I have spoken elaborately on this in my earlier sessions.
Yes. So another question, sir. Complaint by definition is filed only to magistrate. Then how come complaint is filed before court of session?
Cannot. Cannot is our answer. A private complaint cannot be filed before a court of session. In fact, a private complaint filed before the court of session was held to be bad, and the court of session was directed to return the complaint for presentation before the magistrate. That means you have not understood that question. This querist did not understand the answer. I told you that a private complaint was directly filed before a court of session. And court of session took cognizance and examined witnesses and issued process. Accused filed accused challenged the same before the High Court. High Court said wrong. The session judge could not have taken cognizance on a private complaint. It can take cognizance only on a committal. Therefore, the complaint filed before the session judge was bad, and it was held that private complaint ought to have been filed before the magistrate, who will have to eventually commit the case to the court of session.
Right, sir. So can court of session also tender pardon post committal proceedings?
Yes, it can be done at any stage. That's what the section says. 306 CRPC.
Right, sir. So there's another question. I believe this is the last question. What is section 210C BNSS mean? Can magistrate by his own information file a case and take cognizance? So if you can also provide some practical examples, that would be great, sir, if possible.
On taking cognizance by a magistrate, I elaborately explained the procedure. The fourth source of taking cognizance is his own knowledge of the magistrate. I told you that the magistrate, after his court work, going on an evening stroll, walking through the road on an evening stroll, and a cognizable offence is committed right in his presence. He is the only functionary in the whole criminal law who can take cognizance of an offence committed right in his presence, in his very presence. I told you that he can take cognizance. I also told you that once he has taken cognizance, he is in the position of a complainant. He stands in the shoes of a complainant. Therefore, he will be an interested party. Therefore, he is statutorily bound to tell the accused that you have got an option to say whether I should try the case in myself or whether any other magistrate should try the case. I told you that it is founded on the principle nemo judex causa sua. No person shall be judged in his own cause. So here is a magistrate who has taken cognizance of an offence committed right in his presence. Therefore, he steps into the shoes of a complainant. Therefore, he is liable to be called as a witness also. Therefore, he gives an option to the accused. Mr. Accused, I have taken cognizance of the offence committed by you. Now, if I try the case, I might be prejudiced. Therefore, please tell me whether I should myself conduct the case or some other magistrate. Normally, every accused will say some other magistrate may try the case because you are in the position of a complainant. All these things I explained.
Yes, sir. So Santosh, I'll share the links to sir's previous videos and the notes, both with you again in the group. So this is the last doubt that we had. And so with this, we bring today's enlightening session to a close. So a heartfelt thank you and our deepest gratitude to you, sir, for not just walking us through the statutory framework and judicial precedents, but also for highlighting the why and what's. So we hope it was absolutely clear to everyone in the audience, all the concepts, and if they still have any doubts, they can write to us and we'll clear them too. I hope you enjoyed this format, and we would like to cover more topics with sir in the future. Until then, thank you so much, sir. Our deepest gratitude. We are indebted, sir.
You're welcome.
Thank you, sir. Keep reading, keep questioning, and keep learning. Have a wonderful evening ahead. Good night.
Good.